Thank you. The Honorable Vice Rector, Prof. Adi, the Honorable Keynote Speaker, Professor Anthony, the Honorable Moderator, Rafika, the Honorable all participation in webinar. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning at Indonesia and good afternoon in Queensland, Australia. Alhamdulillahirabbil alamin is an expression that will not be forgotten to remain grateful to Allah Subhanahu wa Ta'ala for His mercy and grace. We are back together in the framework of the Scientist Webinar Faculty of Law, and salawat to the Prophet Muhammad Sallallahu Alaihi Wasallam. Let me welcome Professor Anthony Kasimetis to the Red Campus of the Faculty of Law, Hasanuddin University. Our thanks to go to Professor Anthony Kasimetis from School of Law, Queensland University, who has the opportunity to give a lecture on issue of lawfare as self-defense against aggression, Ukraine's use of international litigation in the face of armed aggression by the Russian Federation. This topic is very interesting to be discussed in the context of how both countries to look for their own argument to defend for their action, self-defense, and aggression. We hope that this lecture is the beginning of a collaboration that can be carried out by the two law faculties in order to develop a network between universities. In this context, of course, the Faculty of Law, Hasanuddin University, is very welcoming if after the lecture, it can be followed up with exploring cooperation in academic and research between Faculty of Law, Queensland University, and Universitas Hasanuddin. Finally, invite Professor Dr. Engineering Adi Maulana STMPhil as Vice Rector of Partnership, Innovation, Entrepreneurship and Business of Universitas Hasanuddin to give speech and open officially the Scientist Webinar. Thank you for all participation. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Professor Hamzah Halim, for your delightful remarks. Thanks a lot. We move to the next remark, which is the opening remark by our beloved Professor Adi Maulana, who currently in United States at the moment. So please, Prof. Adi Maulana, the floor is yours.
Okay, thank you. Master of Ceremony, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Our respected Dean of Law Faculty of Hasanuddin University, Professor Hamzah Halim. Our honored speaker, Professor Anthony Kasimetis from Queensland University, and moderator and distinguished participants. Ladies and gentlemen, it is my pleasure to open this Top Scientist Webinar Series today. This webinar is actually a part of world-class university program in Hasanuddin University. Let me take this opportunity as well to wish all of you the very best for 2022. Well, actually, I'm in Alabama, US right now, and then it is already 10 p.m. in here. But because this topic is a very interesting topic, so I personally want to participate in this webinar. Well, today's topic is very relevant with our global issue, international defense, especially related with Russian and Ukraine crisis. And then Faculty of Law, Hasanuddin University is one of the best law faculty in Indonesia, and I think it is a very we are waiting for this kind of discussion from a law faculty, and I believe that because there are so many prominent prominent professor from Faculty of Law in Hasanuddin University, and then that the prominent professor from Faculty of Law of Hasanuddin University also have so many colleagues from other university, especially from Australia. And then today we have Professor Anthony Kasimetis from Queensland University. So we will be waiting for very fruitful discussion related with this global issue. As we know that Russia and Ukraine invasion has triggered many changes globally. Ukraine and Russia, we know that they are key exporters of wheat, corn, and cooking oil, particularly for African and Middle Eastern countries, and also for Europe. And then we know that Russia is also a major player for petroleum and energy, gas. So it means that disruptions to the flow of these goods are, of course, there will be sort of like influence in supply chain, and then also climate challenges driving up food and gas, and then make the price up and causing some shortage in the food and also in the energy, and then also pushing millions of people into hunger. And then today's topic is a very interesting. Why? Because we know that even though I'm not from Faculty of Law, I'm from engineering faculty, but I know that lawfare is the use of legal system and institutions to damage or delegitimate an opponent, or to deter individual usage of their legal rights. And then because we only know the big picture, of course, I do hope, and then we also hope that this today discussion will be fruitful one, and then will give us many information related with this kind of issue. And then Hasanuddin University vision to become a center of excellence in human development, science, technology, arts, and culture based on the Indonesian maritime continent. Of course, with this vision, we also want to take a role not only in regional area, but also in the global area. And then we also want to take a part in order to make peace. At least with this discussion, we know that in the future we will have a very big frame on what is going on, and then so we can set up our preparations to face this uncertainty. So before concluding, the moderator or the master of ceremony asked me to formally open this webinar, and then I would like to convey my appreciations to the speakers for the time and support in contributing to this seminar. I know that in Australia it's already in the evening, but thank you, Professor Anthony. You still want to provide your time to share with us. And then also I would like to give my appreciations to my colleagues in UNHAS, and also from outside UNHAS to present in this webinar. And then for the organizing committee of this event, who already do a very good things to organize this event in these challenging circumstances. So on behalf of Hasanuddin University, Rector of Hasanuddin University, I formally open this webinar. I thank you all participants most warmly for your participation. With that, I open this webinar and wish you all success with this seminar. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Prof. Adi Maulana, for opening this our webinar today. Since it has been officially opened by our beloved Vice Rector, now we proceed to the main agenda, which is the general lecture. It will be delivered by Professor Anthony Kasimet from University of Queensland, Australia. And also during this general lecture, this webinar will be taken over and guided by Miss Rafika Nurul Hamdani Ramli, who also a young lecturer of Faculty of Law and also an alumnus of UQ from Australia. And without further ado, Miss Rafika, you may take the floor, please.
Thank you very much, Mr. Saramani Dewa. And good morning, everyone. I would like to thank you very much, thank Professor Hamzah Halim as the Dean of Faculty of Law for the welcome speech, and also Professor Dr. Engineer Adi Maulana, the Vice Chancellor for Partnership, Innovation, Entrepreneurship, and Business for the opening speech. I would like to introduce myself. My name is Rafika Ramli, and I will be the moderator for our this morning webinar. So before I proceed to our main agenda, I would like to read a brief overview of Professor Anthony, which I have actually just copy-paste from from the UQ website. So hello, Professor Anthony. It's really great to see you again.
Yes.
It's been years.
It has.
Since the last time I saw you in class, and I didn't got a chance to properly say goodbye before going back to my country in 2018, because you were in Cambridge at the time, yeah, if I'm not mistaken. Yep. Okay. So Professor Anthony Kasimatis is a professor at TC Burney School of Law, the University of Queensland. Anthony teaches administrative law and public international law. He is the director of the Center for Public International and Comparative Law at the University of Queensland. He was the chairperson of the Australian Red Cross International Humanitarian Law Committee for Queensland from 2005 to 2008, and he remains a member of this committee, which he joined in 1998 because of his dedication. He has been honored with an Australian Red Cross Award for exceptional leadership. Anthony is the author or co-author of 5 books and numerous articles and book chapters on public international law, administrative law, and legal advocacy. He is the editor-in-chief of the Australian International Law Journal. He has been academic supervisor of teams representing the law school in the Philip C. Jessup International Law Moot Court competition over many years, including teams that have won the Australian national rounds of the competition 2005, 2012, and 2014, and the Jessup Moot Court Championship in Washington, D.C. 2005 and to 2014. And even in 2017, the team was the overall champion in the written component of the competition, beating 127 other teams from 80 countries to win the Alona E-Events Award for Best Memorials. The respondent memorial was also ranked first globally. In the oral component, Ms. Anderson and Mr. Ten were ranked in the top 20 out of around 500 competing speakers. Wow. Our mooters just got so excited when I told you that the Jessup coach from the University of Queensland will present this morning. So, Professor Anthony, without any further ado, the floor is yours.
Thank you, Rafika, and thank you very much for the warm welcome from the Vice Rector, Professor Dr. Adi Maulana, and from the Dean, Professor Hamzah Hakim, and thank you also, Kamara and Maskin. I will share my screen with you, which has my presentation. I'd also like to do what Australians generally do now, is acknowledge the traditional Aboriginal owners of the land on which I'm sitting, which is the Turrbal and the Jagera people. Pay my respects to their elders, past and present. So my topic today, are you all able to see the slides? Is that
Yes,
are the slides?
yes.
Yes. Yep.
Yes.
Excellent.
Crystal clear.
So I will just make that live. So I am speaking on the legal strategy that Ukraine is adopting in relation to the armed conflict that is occurring in its territory at the moment. So obviously, there are lots of other issues. There's the military strategy, there are the economic issues associated with the armed conflict. But I'm focusing in particular on Ukraine's legal strategy and offering some observations on that strategy and the way in which the strategy might work out for Ukraine. So the issues I'd like to do, first of all, I'd like to set out all of the different legal avenues that have been pursued. So there have been a whole range of different legal actions commenced. And I'd like to just give you a quick snapshot of the position in relation to the various cases and various other actions that have been brought by Ukraine, but not just by Ukraine. So they've also been in relation to, for example, the shooting down of Malaysian Airlines flight MH17 in 2014. Australia and the Netherlands have brought actions against the Russian Federation in various places. So the European Court of Human Rights, for example, the International Civil Aviation Organization, and that relates to the situation in Ukraine because obviously MH17 was shot down over Ukrainian territory. So I'll take you through the various cases that have been brought. I then want to talk about how litigation and legal action in a national context. Obviously, in litigation, in court cases in a national context, the parties to the actual litigation are directly involved. But the law also has the capacity through judgments, etc., to influence the behaviour of other parties. And so it's referred to in a national context as the shadow that the law casts, the shadow that the law gives to others in the community, and that they change their behaviour in face of that shadow, that they change their behaviour. And this is a phenomenon which has been identified in national systems, but it is also something that you can see arguably in international relations. And I would like to give some examples which are relevant to both Australia and Indonesia. The way that Australia, for example, changed its position on the maritime boundaries. It was actually cases involving Libya and Malta in the International Court of Justice that forced Australia to alter its bargaining position in relation to its maritime boundary, boundaries to the north. And this is just an illustration of how legal cases can influence not just the parties to those disputes, but also third parties. And I'll give some examples of how I think that is also potentially going to operate in the context of Ukraine. So the third part of the presentation will focus on the specific situation involving Ukraine and how the litigation strategy may work out for Ukraine. And then I'll make some sort of concluding observations. So just a preliminary point, in terms of the terminology, I'm using in this talk the expression aggression against Ukraine. And in that sense, I'm using the language that the General Assembly adopted in its resolution on the 2nd of March in 2022. So it was adopted formally, that language was adopted formally in the resolution adopted in the emergency session that was called after Russia's invasion in February of this year. And the resolution, as you can see, is entitled Aggression Against Ukraine. It was adopted not unanimously. There were 5 states that voted against that resolution, but the overwhelming majority of states, including Indonesia and including Australia, endorsed that language, aggression against Ukraine. And so that is the basis on which I'll use that terminology. So just to basically take you through very quickly all of the different cases that Ukraine has brought against the Russian Federation. And these cases begin after 2014. So after essentially the annexation of the Crimean Peninsula, so in the south, the Crimean Peninsula, and also the action taken by separatist forces in the east of Ukraine, in the Donbass region, which occurred in 2014. The Ukrainians commenced litigation in the International Court of Justice, alleging violation of two treaties, the Convention for the Suppression of the Financing of Terrorism and the International Convention on the Elimination of Racial Discrimination. The Russian Federation objected to the jurisdiction of the court, and the court rejected the Russian Federation's questioning of the court's jurisdiction in 2019. Now, that case hasn't been resolved. It is ongoing. The court in 2019 essentially said, we have jurisdiction to hear this case, but they're still obviously considering the merits of the case. In addition to that action before the International Court of Justice, Ukraine also commenced an action this year, a separate action, alleging that Russia's accusations of genocide against Ukraine were not justified under the Genocide Convention. We've only had a very early sort of involvement of the court in that regard. So the court made an order on provisional measures in March of this year, but it hasn't yet determined whether it will hear the case. It's at a very early stage. There are two separate actions, one involving the Convention on the Genocide Convention, the other involving the treaties on terrorist financing and the Convention on the Elimination of Racial Discrimination. In addition to those actions before the International Court of Justice, after the 2014 Russian action and measures restricting the movement of Ukrainian goods across the territory of the Russian Federation, Ukraine commenced proceedings in the World Trade Organization, which culminated in a panel report by the World Trade Organization in 2019, where Russia was largely successful in invoking, it was accepted that there would be a potential breach of the World Trade Organization by Russia's measures, but there's an exception in the World Trade Organization agreements for measures taken for the purposes of national security. So the panel in that case accepted that Russia could invoke that exception for national security in respect of those trade measures. We'll see, though, that the case, even though on its face Russia had some success in that case, the Russian Federation's success has actually ended up being damaging to the Russian Federation in relation to the subsequent action that has occurred, relying on the same defense in relation to national security in respect of subsequent measures that have been taken, which I'll come back to when we look at the position specifically in relation to Ukraine. In addition to the International Court of Justice and the World Trade Organization, Ukraine has also brought a number of actions under the UN Convention on the Law of the Sea. So it brought an action essentially involving its law of the sea rights in respect of the Crimean Peninsula, which was largely unsuccessful as well. And it was an arbitration under Annex 7 of the Law of the Sea Convention, which went largely in the favor of the Russian Federation on a technicality, in the sense that the arbitral body essentially took the Ukraine's case to involve or require the arbitral body to decide who was the sovereign of the Crimean Peninsula. And so the Annex 7 arbitral body said it couldn't decide the sovereignty over land territory, which was essentially required in order to work out who was the coastal state for the purposes of working out the rights under the Law of the Sea Convention. So, so there's that case. There's also a couple of cases which are ongoing involving the seizure of Ukrainian naval vessels, which occurred in 2018. So a flotilla of Ukrainian naval vessels were seized as they were attempting to enter the Sea of Azov in the area of Crimea. And so Ukraine commenced proceedings, or has commenced proceedings which are ongoing, both under the they're both under the Law of the Sea Convention in respect of the seizure of the vessels and the detention of the naval personnel. So the vessels have been released and the personnel have been released, but the litigation is ongoing in terms of liability. And so you have an international tribunal for the law of the sea action ongoing, and also an arbitration under Annex 7 of the Law of the Sea Convention, which is ongoing. So, so those two actions are running. The earlier action was in respect of the coastal state rights, in respect of the Crimean Peninsula. This action was in relation, or these two actions are in relation to the seizure of the vessels and the detention of the naval personnel. In addition, Ukraine has commenced proceedings before the European Court of Human Rights, alleging human rights violations in respect of Crimea. And that case is ongoing as well. So the Russian Federation contested jurisdiction. The Grand Chamber of the European Court of Human Rights last year rejected the Russian Federation's arguments, and so the case is now proceeding to a consideration of the merits. In some ways, this case is similar to the Ukrainian argument before the International Court of Justice on the Racial Discrimination Convention, because essentially these cases relate to alleged discrimination by the Russian Federation against the Muslim Tatar population of Crimea, and also against Ukrainian nationals in the Crimean Peninsula. In addition, I mentioned that other states have brought action regarding conduct in Ukraine. So, the Netherlands has brought an action before the European Court of Human Rights against the Russian Federation in respect of the shooting down of MH17. The Netherlands has also joined with Australia in commencing proceedings in relation to the shooting down of MH17, allegedly by Russian military personnel in 2014 before the International Civil Aviation Organization. And the Ukraine has also commenced criminal proceedings against Russian nationals before its national courts in respect of the shooting down of Malaysian Airlines flight MH17. And all of those actions, I think the criminal prosecution might have actually given its judgment, but the human rights action before the European Court of Human Rights and the civil aviation action, they are ongoing. The Russian Federation has also brought an action before the European Court of Human Rights. It brought an action last year against Ukraine alleging human rights violations in respect of the Eastern Donbass region. And it requested last year that the European Court of Human Rights issue provisional measures, which and the court refused. So that litigation is, I think, also ongoing. In addition, Ukraine has consented to the International Criminal Court investigating alleged violations of the prohibitions on war crimes and crimes against humanity. So the International Criminal Court is investigating the situation in Ukraine, and that slide is just taken from the International Criminal Court website. And in addition, there are various private entities which have brought, and in some cases succeeded, in cases related to Russia's annexation of Crimea. So there have been a number of cases brought under bilateral investment treaties against the Russian Federation, alleging essentially that investments by corporations in Crimea have been harmed by the Russian Federation's action. And in some cases, there's been findings of the investors having their rights interfered with by the Russian Federation. Not all of the judgments are publicly available in that regard, but at least one of them, the case involving the Starbil company, Ukrainian company, that judgment is available. And so there have been these bilateral investment cases brought against the Russian Federation, not by states, but by private companies that have had investments in particular territories. All right, so the next, turning to the next issue, which is obviously each of those cases are going to have a direct effect to the litigants, but I want to focus for a moment on the way in which legal cases can influence third parties, and also how legal cases can have an indirect effect on a dispute between, for example, two states. And this is sort of sometimes referred to as the way in which the law casts a shadow, and it's sometimes referred to as the way that third parties bargain with each other in the shadow of earlier cases, in the shadow of the law. So there's a famous article in the Yale Law Journal from 1979, where in the case of US law, in relation to divorce, the idea that people in going through divorce will look at the earlier cases involving other people and will adjust their behavior based on the cases. So the earlier case law involving other parties is influencing the way in which parties negotiate, etc. And this idea is present in the scholarship on international law, the way in which litigation can have an indirect effect on third parties. And I want to give an example of this in the context of our region, and it involves how Australia changed its position on maritime boundaries. So in the 1970s, because of the developments regarding continental shelves, it was pretty common for states to argue that maritime trenches, such as the Timor Trough, maritime trenches were relevant when working out boundaries, because in a sense, Australia would argue that this was the continental shelf of the Australian landmass. And so on that basis, the 1972 seabed boundary between Australia and Indonesia was agreed, and Australia took the position that the Timor Trough was relevant. And there was a good argument, I think, in the 1970s along those lines. But after that, two significant developments occurred. One was the negotiation of the 1982 Law of the Sea Convention, and the other was the International Court of Justice's decision in the case between Libya and Malta. Now, the 1982 Law of the Sea Convention basically recognized all coastal states' entitlements to continental shelves out 200 nautical miles, regardless of the geology, regardless of where the actual end of a continental shelf was. And so when Libya, in its dispute with Malta in the 1980s, said, well, there's a rift apparently, which Libya argued between the island of Malta and the Libyan coastline, and Libya argued that that rift, that depression, was relevant in the drawing of the maritime boundary. And the court said, no, the rift is not relevant to the drawing of the boundary. And so with that judgment, Australia was not a party to that judgment, but the Australian position became much more difficult to argue. It couldn't refer to the Timor Trough any longer as a justification for adjusting the boundary along those lines. The judgment in this case involving third parties was casting a shadow. It was affecting the position. And so Australia, and this is not yet enforced, but as far as the exclusive economic zone between Indonesia and Australia, there was a treaty which is Indonesia has not yet ratified, which basically extends the EEZ closer to Australia. So Indonesia would have EEZ rights in respect of these waters, which are closer to Australia than the 1972 boundary, which was there. So that difference is because of that judgment and because of the 1982 Law of the Sea Convention. And equally, in relation to the 2018 agreement with Timor, you can see that the 1997 EEZ arrangements with Indonesia have also, in a sense, coloured the boundary. So that movement of the boundary closer to Australia is an effect of the ICJ's judgment and the 1982 Law of the Sea Convention changing the legal landscape, or the underwater landscape in this regard, in terms of the positions. There's also another interesting dimension, which is a sort of commercial dimension. In the negotiations between the UN administration for East Timor prior to Timor-Leste's independence, the UNTAET, the UN administration, wrote to the Australian government and in 2001 and claimed that the contracts that had been negotiated with oil and gas companies, the contracts that had been negotiated in the 1980s were not very favourable to Australia and Indonesia. And what the UN administration argued was the uncertainty regarding the status of East Timor before the United Nations allowed the oil and gas companies to negotiate there was a risk essentially in terms of title, and therefore they were able to negotiate more attractive royalty arrangements. So again, this is a third party taking advantage, in this case, the oil and gas companies, taking advantage of the legal uncertainty and then using that to its advantage. And then obviously with greater certainty, subsequently, the UN administration was arguing that East Timor should have been given a better deal in terms of the oil and gas revenue. Now, obviously, Australia was deeply embarrassed by the spying allegations, which I think as an Australian were quite shameful in terms of what the Australian government did in that regard. But that's obviously a separate issue. This is just in terms of how legal uncertainty can affect not just the way states behave, but also the way commercial entities behave. And this point is made by a PhD student at the Australian National University. I'm quoting in this quote from that PhD thesis. Now, the final thing in terms of third-party effects, which I want to note, is in the Bosnia Yugoslavia litigation, the International Court of Justice was asked by Bosnia to rule on the responsibility of Serbia and Montenegro in respect of the genocide at Srebrenica and other violations of international law. And obviously, the International Court of Justice is an institution established to hear disputes between sovereign states. And obviously, a lot of the accusations in this case, given that was accusations regarding the violation of the Genocide Convention, involved individuals committing the crime of genocide against other individuals. And so the court, the International Court of Justice is not well placed to call individuals to give evidence and to cross-examine, etc. And what the court does in its judgment in 2007 in the case between the two states, between Bosnia and Serbia and Montenegro, which were at the time in a federation, is essentially rely, in terms of the underlying facts, the International Court of Justice relied, amongst other things, on the judgments of the International Criminal Tribunal for the former Yugoslavia. So the facts regarding the war in Bosnia and the genocide at Srebrenica against the Bosnian Muslim population, those facts, the International Court of Justice used the previous case law of the ICTY, which didn't involve state responsibility, it involved individual criminal responsibility. It used the case law of the ICTY, the International Criminal Tribunal for the former Yugoslavia, to come to conclusions regarding the legal responsibility of the state of Serbia, Montenegro. So the individual criminal responsibility case law influenced the court regarding the state responsibility issues. That is, I think, important. The court said, the International Court of Justice said, we need to distinguish between, say, a preliminary hearing before the International Criminal Tribunal for the former Yugoslavia, which we won't place much weight on, and say a decision of the appeals chamber of the International Criminal Tribunal for former Yugoslavia, which the International Court of Justice said it would place significant weight on. All right, so how is all of this relevant to the Ukraine crisis? Well, first of all, in relation to the two cases which Ukraine was unsuccessful in, I indicated to you that actually this has worked in favor of Ukraine, because what has happened is, in response to Russia's aggression, many states have suspended Russia's WTO rights, for example. And so you had, in March of this year, a group of states, including Australia and all the members of the European Union, suspending the Russian Federation's right under the WTO agreement. And they've relied on the essential security interest argument, which they've effectively relied on the case law that the Russian Federation contributed to against essentially the Russian Federation. And so these states have been able to rely on this, and there is much greater legal certainty because of that earlier Ukrainian case. So that's the first thing. The other thing I would note is that on the other side, a lot of the oligarchs, the Russian nationals who've had their yachts confiscated, etc., are also now beginning actions under bilateral investment treaties. And we'll see those cases starting to be brought. They're not obviously being brought by the Russian Federation itself. They're being brought by Russian nationals who claim that their investments in Western countries have been damaged, and there'll be arguments, no doubt, about national security, etc., in that context as well. The other aspect, which is a little bit more complicated, is the failure of Ukraine in its case against the Russian Federation in respect of its coastal state rights. That decision went against Ukraine in 2020, but Mauritius ran a case more recently where the case where Ukraine failed was disagreed with in a dispute between Mauritius and the Maldives. Now, to explain this, I need to go a little bit into the strategy that the strategy which Mauritius has applied in respect of the Chagos archipelago. So I'm sorry if you're all familiar with this, but just to orient ourselves. So you've got Mauritius in the Indian Ocean, and you have the Chagos archipelago, which was part of the British colony of Mauritius, which the British purported to separate off from the Republic, from the colony of Mauritius, just before its independence, in order to essentially give to the United States a lease for a naval base, an Air Force base, sorry, at Diego Garcia, which is part of the Chagos archipelago. So Diego Garcia is there, and this is a close-up of that particular map. So Mauritius has run a range of different actions which have been very effective for Mauritius. So it brought an action against the United Kingdom under Annex 7 of the Law of the Sea Convention, which it was partly successful, partly unsuccessful in 2015. It then was successful in encouraging the General Assembly to request an advisory opinion, which the International Court of Justice gave in 2019 in favour of, it's an advisory opinion on the decolonisation process involving Mauritius, but that advisory opinion was very hostile to the UK's position. And then the General Assembly essentially passed a resolution endorsing the International Court of Justice's position with a very strong majority in favour, essentially, of Mauritius. And so what ends up happening is then the Maldives and Mauritius enter into negotiations over their continental shelf. And at some point, the Maldives stops cooperating with Mauritius and starts arguing that it shouldn't be negotiating with Mauritius, it should be negotiating instead with the United Kingdom, because the United Kingdom is the sovereign in respect of the Chagos archipelago. And so this goes before the International Tribunal of the Law of the Sea in 2021. And in that case, the International Tribunal of the Law of the Sea disapproves of the Ukraine case and says the UK's position is untenable. The UK cannot argue that it is the sovereign in respect of the Chagos archipelago. The UK could not argue that, according to the International Tribunal of the Law of the Sea, because the ICJ had ruled in the advisory opinion and the General Assembly had voted in the way that it did. And so I think this is indicating where Ukraine will go with all of the cases it's running. The cases that it is running are all going to be developing judgments where the Russian Federation's conduct is being scrutinized. And the courts, whether it's the International Court of Justice or the European Court of Human Rights, are going to make findings regarding the facts on the ground in eastern Ukraine and in Crimea. And eventually, with those judgments, if those judgments basically reject the arguments that the Russian Federation has run in respect of, you know, crimes against the people of eastern Ukraine, or in relation to its conduct in Crimea, whether or not Russian military personnel were involved in seizing control in Crimea, which the Russian president on television has already admitted to. Once those facts are in judgments in cases where the Russian Federation has put its version of events and it's been rejected by a court, the position of Ukraine will be potentially stronger. And the possibility of Ukraine, I'm not saying it's as strong a position, but there is the possibility that Ukraine will be able to do essentially what Mauritius has done in its dealings with the Maldives, and say, you must negotiate with us. We are the sovereign of the Chagos Archipelago. Essentially, through this strategy, Ukraine may be able to make a similar argument regarding eastern Ukraine and Crimea. Now, in terms of the Russian Federation's action, my own view is that I think that the Russian Federation's military action threatens more than just Ukraine. In the very insightful introduction that was given about the way in which the conflict has affected grain and oil supplies and sunflower oil, etc. There is that effect as well. I would, in terms of concluding observations, I would emphasize the observations made by the ambassador for Kenya in the UN Security Council, who basically said to the Russian Federation, we understand your historical claims vis-a-vis the Crimean Peninsula, but you have recognized that border. Our borders in Africa, he said, were drawn in London and in Berlin, etc. And Africans understand that even though our people are separated by these borders that were drawn by Europeans, we cannot reopen those borders. If we reopen those borders, we open up our continent to constant conflict over the position of borders. And this idea is, I've included in this slide an extract from the International Court of Justice decision in the dispute between Burkina Faso and Mali in West Africa, where the principle of uti possidetis, the idea that a newly independent state will succeed to the colonial boundaries of the colonial power. And so, you know, Indonesia's claim over West Papua is tied up with that in terms of its sovereignty is based on the fact that the Dutch were the colonial authorities in the Indonesian archipelago and in West Papua. And so, and the court pointed out why African states and Asian states have treated borders as being so important, because the purpose of recognizing the borders is to prevent the independence and stability of states being endangered by, you know, conflict that is provoked by challenging the frontiers of borders that have been negotiated. And so African states, I mean, the idea of the borders being continued developed first in the Americas when Spain and Portugal withdrew from Central and South America, but it's been adopted in Africa and in Asia, and for good reason. I don't know whether or not Ukraine will be successful militarily in its resistance against Russia, but I fear that if Ukraine fails, then the world will go into a new era of arms races. Both, we're already seeing the beginning of this, conventional weaponry and also nuclear weaponry, because President Putin has been quite open in mentioning the nuclear option. And if he succeeds in taking part of Ukraine's territory through the threat of nuclear weapons, he will encourage other similar leaders to acquire nuclear weapons and then threaten their neighbors. Both the arms race in conventional weapons and in nuclear weapons will mean that economic resources are being diverted from education and health and other areas which are central to human development, and be instead applied to the acquisition of arms. So that is my presentation. Thank you very much for your attention, and I will stop sharing my screen and open up if there are questions.
All right, thank you very much, Professor Anthony. That was really intense presentation. And now I'd like to open for a Q&A session. If anyone has a question, you can just push the raise hand button, or you can type your question in the chat box. Is there anyone from the forum who would like to ask a question? If not, let me start first.
Ibu Rapika, just suggestion, Ibu Rapika, just open for all the participants to speak Indonesia and then try to translate in English to it would be better probably. Yes, just suggestion.
Yeah, thank you very much, Pak Maskun. Professor Anthony, I will conduct this session in 2 languages. Jadi untuk peserta, jika mempunyai pertanyaan untuk Profesor Anthony, silahkan ajukan raise hand dalam bahasa Indonesia, atau nanti saya terjemahkan ya. Kalau tidak juga silahkan ketik pertanyaannya di chat box. Jadi tadi presentasinya itu Profesor Anthony menjelaskan tentang legalitas menggunakan Rusia ya dalam perang Rusia dan Ukraina. Jadi beliau itu memaparkan beberapa kasus sebelumnya. Oke, please, Mr. Riyad, you can open your mic and ask question.
Can you hear my voice loud and clear?
Yes, it's clear, Riyad.
Okay. First of all, thank you very much for Ibu Rafika and everyone involved in arranging this webinar. This is fantastic. We are, especially us from International Law Department, is really looking forward for this sort of enlightenment on this issue. And we particularly, and also we really respect the presence of Professor Kasimatis in here to give us a lot of insightful ideas on how the effect of legal proceeding instituted against Ukraine. But for me specifically, I think the first open question will be how we could understand, because I think the topic is centered around the lawfare itself. Then I'm interested to your take on what is the scope when we try to say lawfare as a concept. Because if we talk lawfare in the lens through international law, if by your examples you mentioned initially about the international court proceedings, you also mentioned several proceedings in WTO and etc. I think that what we commonly understood the issue was that first, this proceeding took forever to be resolved. It took years, and for those proceedings, I mean, in light of the conflict itself, the conflict is quite dynamic. It happened fast, swiftly, and usually by the time those proceedings ended or even investigated, it's quite difficult to like wait to the merits in itself. And even if the proceeding itself is completed, and then say we declare, for example, hypothetically, Russian aggression is indeed there, there's also the question about compliance, clearly. Russian probably will not comply. I mean, there's a lot of cases, to my knowledge, that ICJ itself will not, the party member itself will not comply to the ruling of International Court of Justice. So in that regard for lawfare itself, I think it's quite narrow to see it merely as a concept of international law. What I, at least in my understanding of lawfare in this context of conflict, we also see some law that was developed through the national laws, national legislation of Ukraine itself, that's sort of like affecting the whole situation of the war. Like, for instance, I think recently there is not recently, there's a law that sort of like legalized the sale of tanks, a Russian tank that was confiscated in Ukraine region. And then there's also a law that's actually, it's not really directly relevant to the outcome of the war itself, but it gained a political traction. Like, for example, Ukraine decided to legalize the gay marriage, the LGBTs proceeding, the LGBT marriage in the country. And on the same end, Russia decided to prohibit all the, what you call it? The campaigns directed against LGBT. And this sort of creating this proxy, sort of like alliance between the West, like Ukraine solidified its position that it want to embrace the European stance on the freedom and etc. On the opposite end, Russia is trying to like oppose all of that. So I think those kind of lawfare, creating this law as a product to make a political statement, or in itself affecting this the situation of the warfare itself, maybe should be considered also as a lawfare. What's your take on that? Thank you.
Yes, no, I agree. I think that, I mean, obviously lawfare has a negative connotation, but it also, I think it can also, I mean, no one is forcing Ukraine to bring the actions that it has brought. It's doing it because it thinks those actions are in its self-interest, and it would understand that enforcing the judgments that it obtains in its favor is going to be difficult. So, but it still brings the action. So it obviously has a view about the effectiveness of this. I definitely agree that the national position is relevant in terms of lawfare, and I think that, you know, Russia's obviously specifically referred to the reference, I think, in the Ukrainian constitution to joining of NATO, etc. And so that obviously has a role to play in the politics and the international relations. I would push back against the Russian, I would say, propaganda in relation to social issues like LGBTQI issues. My cousin is a monk in Greece, and his monastery has a chapel in Red Square, etc. And a group of Orthodox Christian theologians from all around the world have condemned the attempt to use LGBTQI issues as a justification for aggression. So this attempt to sort of paint this as a civilizational issue is contested, and as an Orthodox Christian myself of that tradition, I would see the Russian church's position as being, you know, the Christian position as being heretical, to say that you can go to war essentially because of social policies in a neighbouring country regarding the rights of people in that country. So for me, leaving to one side whether you should or shouldn't how you should deal with those issues in a national system, it is not a justification for war, and it is a perversion of Christian doctrine to try and say that it is a justification. So I agree with you that it is relevant with the way national systems go, but I'm also conscious of the fact that, you know, President Putin was a lieutenant colonel in the KGB, and he's a master of sowing division and uncertainty and getting countries to fight against themselves on issues. And I see the attempt to inject discussion of social issues and to try and separate Russia civilizationally from the rest of Europe. I just find it implausible, and actually I share the same religion essentially as Putin, but I think he is wrong completely in relation to that. So.
Is that clear, Mr. Riyad?
It's amazing. It's amazing. It's like if there is no question, can I ask a follow up? Maybe just ask a question first, Ibu.
Sure.
Yes, please.
Oh, can I follow up?
Yes.
Yes, sorry. Thank you very much, because this is a really engaging topic. And so, yeah, I agree on you on the front of how even the social issue itself was combined, merged with the law itself. And then as a result, it created this kind of division on justification of how we could become the part of certain alliance and how we could justify the war in itself. And that's pretty much happening in Ukraine right now. And what happened also in that regard is that how this lawfare in itself affect in the macro level to our non-state actor in itself. That is something I'm interested to see your take. So like for instance, so I work, I'm also currently work as a consultant in one of the NGO in Myanmar. And one of our interests was that to provide information to the international organizations that try to like find out what is happening currently in Myanmar. And usually when there is a new rulings or new decisions, is it a position from the United States or the position of United Nations, we sort of have to react those. We sort of have to like document the reaction of local society and also even the NGO and etc. And I think this is the front where lawfare in itself, lawfare through the international proceedings and all that, it really affecting the prospect of the war. So for instance, in the, I think, yeah, in this year application of genocide proceedings that was instituted by Gambia to Myanmar, mm-hmm. Of course, the International Court of Justice deny the challenge by Russian related to jurisdictions and claim it has jurisdiction on that. Of course, if we see it from the international level itself, this opens up the room for third party to institute proceedings against genocides. But that's not necessarily the case in itself for these local people, for these NGOs, community-based organization working in Myanmar, because they sort of have these validations. So they make this report to sort of convince the community that what the military government, the junta did was illegal through the international community eyes. And that's sort of like, especially for those CSO or community or ethnic armed insurgency group, that's sort of leaning towards the national unity government, which is the shadow government from Myanmar. They're sort of like trying to use this claim as their support in instance. So I think in this, if you see it in the context of Ukraine in itself, how this positioning of like the decision, I think the resolution by the UN related to the aggression in Ukraine, or for example, the currently in process litigation on Malaysian airplane that was shot down, how it sort of like affect in micro level toward this community in this whole conflict. Thank you.
I think that's an excellent point, and I definitely think that there is the potential for civil society related organizations to rely on, again, the factual findings in cases. So that, you know, if you take, for example, the European Court of Human Rights litigation, the Russian Federation appeared before the European Court of Human Rights, unlike in the proceedings brought under the Genocide Convention, where they didn't even appear. They appeared and they made arguments. So the court will now have the opportunity, the European Court of Human Rights will have the opportunity of ruling in respect of what the Russian Federation has said about Crimea. And if they say that there is no basis in fact for the position, then it will assist not just the Ukrainian government, but it will assist people in the region, because you will have findings. Now, obviously, the Russian Federation will ignore those judgments, but in terms of the improving of the position of people to have a body which is independent, ruling on the factual argument, it becomes more difficult for the Russian Federation in light of that judgment. And then there's also the commercial arrangements. So, you know, if Russia is seeking to get investment in its territory from the West, this is going to be, so corporations are going to be more, I mean, they're already withdrawing, and obviously, you know, their corporations would be very, I would have thought, concerned about Russia's territorial claims, you know, like attempting to invest to extract oil and gas from around Crimea. You know, how secure can you be? So, I mean, Russia presumably will have to finance itself, or it may find some other state that's willing to finance that, but it will not be able to raise funding as easily as it would have if its title was accepted. And the lawfare is contributing to that cost, essentially, to the Russian Federation, because it's destabilizing the Russian claim to sovereignty. It's destabilizing the Russian narrative about how the circumstances developed. So I definitely think that non-state entities are going to be using the judgments that are coming out in the same way that, you know, the case being brought by the Gambia against Myanmar has, you know, potential to assist groups assisting the Rohingya in respect of the genocide that occurred in Myanmar. So.
All right, thank you very much, Professor. Is there anyone wants to ask question from the floor? So, jadi presentasi dari Profesor Kasimatis tadi itu membicarakan tentang bagaimana si Ukraina ini menggunakan lawfare sebagai legal basis untuk melakukan self defense melawan agresi dari Rusia. Jadi Profesor Kasimatis tadi menyebutkan beberapa contoh dari kasus-kasus yang sebelumnya yang dapat digunakan oleh Ukraina sebagai alasan untuk menggunakan agresi sebagai lawfare untuk self defense gitu. Dan tadi pertanyaan dari Pak Riyad mendiskusikan tentang bagaimana lawfare itu bisa sampai affect micro level, ya, jadi seperti itu. Ada dari forum lagi yang ingin bertanya, yang bisa untuk dalam bahasa Indonesia, nanti saya translatekan.
Okay, can I speak, please?
Oh yeah, Mr. Maskun, please.
Okay. First of all, I would like to say thank you so much for your great presentation, Prof. Anthony. I just want to know, according to you, can you predict what the best should Ukraine do in terms of this facing this war with Russia? Whether they would be bringing this case into international court of justice, or what the best solution actually? This is something in my mind. Actually, I would like to see your perception actually regarding to this war between Ukraine and then Russia, because there are so many possibilities that scholars mention in their paper and when they speak, but probably I would like to know in point of view. Thank you.
Yeah, it's a really good question. It's a really hard question because to know what the best strategy for the Ukraine is, you kind of need to know what is in Vladimir Putin's head, like what he's thinking, and what he's prepared to do. Because obviously stopping the fighting is the most important thing, because it is impoverishing the people of the region. It's impoverishing, it's killing, obviously, the victims of the conflict. It's killing civilians. It's killing Russian personnel. It's killing Ukrainian personnel. And mothers on both sides of the border will be welcoming home their young killed in the conflict. And it's a human tragedy. And so ending the conflict is obviously important. But given that Russia wasn't satisfied with it would have, I think, if you'd asked me before February 24 this year, whether Russia could have kept Crimea, I would have said it's likely that the international community will eventually put pressure on Ukraine to accept Russian sovereignty over Crimea. But with the invasion on 24 February, everyone is now thinking, if you give in to Vladimir Putin on Crimea, he'll keep pushing for more. And so I imagine the Ukrainians are thinking, we need to adopt a strategy that imposes as much of both a military cost on Russia and an economic cost on Russia that will eventually force Russia to the table to negotiate. And that's what I think they're trying to do. Whether they succeed or not depends in part on how secure Vladimir Putin is in the Kremlin and what he actually wants and what he needs to survive. So I don't know, but I think the Ukrainians want to stop the fighting, but they realize that if they just give in, he's going to keep asking for more. So they can't give in. They have to fight. And then it's a question of, what ways to fight. And obviously you can fight using weapons, but you can also fight using legal challenges. And obviously my presentation is on the legal challenges. That is a way in which they're essentially trying to defend themselves.
Thank you very much, Professor Anthony. Mr. Maskun, is there any further question?
No, it's okay. Enough.
Okay.
Thank you.
I saw someone just raise hand before Pak Maskun. Do you still want to continue?
I would like to ask a question.
Thank you.
Am I audible?
Yes, but it's quite noisy behind you.
Oh yeah, sorry about the noise, all the stuff. Thank you for the time. I'm sorry for not probably joining sooner, but I'm gonna ask some stupid question first. Like, I don't think that this is actually about the lawfare itself, but I think it's more of like the interest who wanted to take an opportunity since the Ukraine crisis. I think it's around like 2010. And I think they wanted to be the one who withhold such power of the economic and trade and strengthen the power which hold the ground for the federation itself. I don't know. I think it's like more of like governmental issues rather than just like trying to defending like the legalities grounds, such as they just wanted to defend. I think it's like they try to defend the sovereignty of the state, and also for the Ukraine. Meanwhile, for the Russian side, it's like more taking back the power of like back of this, like the old Soviet. If that's actually if that makes any sense at all. Sorry for the loud noises.
Thank you, Mr. Nuril.
Yes, so I'm not sure if I picked up all of the questions. If I understood you correctly, Nuril, you're asking, is Russia just trying to go back to the Soviet sort of position? And I think definitely that is, I mean, Putin was a KGB lieutenant colonel in Berlin, in East Berlin, at the time of the collapse of the Soviet Union, and he plainly would prefer to go back to the circumstances that you know, the Soviet Union was in, but that's no justification for doing that. You know, that's essentially taking away the autonomy of a whole group of countries that prefer not to be part of the old Soviet system. It's essentially an imperial aim that Putin is seeking to achieve. And just as we, I think, rightly required the British and the Dutch and the French to surrender their imperial possessions after the Second World War, we shouldn't be encouraging countries going back to that style of domination. Now, obviously, you can argue that there are economic domination, but I think that economic influence is different to having tanks in your territory telling you directly what you can do. And I think that, obviously, the US has behaved wrongly. I mean, I was in the group of scholars who considered the invasion of Iraq in 2003 to be a violation of international law, and I still think that that was a violation, but at least the United States got out of Iraq. At least the United States has not tried to make Iraq part of its territory. That is a big difference with what is happening with Ukraine. It seems quite clear. It's happened already in respect of Crimea, where it's been formally annexed. And it's clear from announcements being made about the holding of votes in the occupied areas that the Russian Federation is moving towards dismembering Ukraine and taking its territory and making it part of the Russian Federation. And that is a very different sort of imperial type ambition, which I think it scares me in terms of our region, in terms of major powers, and I think scares other people around the world in terms of the sort of world to resist states that have those imperial ambitions. We're all going to have to spend more on defense. We're all going to have to spend less on education and health, etc., to resist a neighbor who has the desire to claim part of our territory. So I don't know if that addresses your question.
Thank you for actually clarifying this stuff. Yeah, actually, I was actually mirroring the fact that back in 2003, that U.S. attacked Iraq for kind of fake kind of theories surrounding the state, and with the way that you say that the current crisis of the Russian and Ukraine is pretty much like it's like literally invading like the sovereignty of the state itself. So yeah, I think it is much more intriguing to discuss about this, and since that it is important that we know the common basic to how to understand the situation in that stuff, since all this is literally leading up back from the early 2000s. So yeah, thank you.
Thank you. Thank you very much. Another question from the floor. I think we still have 5 to 10 minutes before I close. So if there is no question from the floor, I would like to ask a question, Professor.
Mm-hmm.
Well, actually, I've been after hearing all the your presentation and the questions from the participants. So I'm kind of wondering what's the purpose of the lawfare itself.
Yeah, I think it's to put as much pressure on the Russian Federation to encourage the Russian Federation to stop fighting. That's what I think the lawfare is intended to achieve. It's obviously not being successful at the moment because the fighting is continuing, but and it's also not being successful in part because, you know, Saudi Arabia hasn't decided to increase its oil production, so the oil price has been very high, and so Russia has earned a lot more money from its oil and gas sales. So, you know, so the geopolitical issues are complex, but what Ukraine, I think, is trying to do is increase the cost for Russia. And again, as I said to Maskun, whether that's successful in part depends on what is the thinking of the Russian government and how much cost they're prepared to incur, you know, how much, you know, how serious they are about this. And if they're very serious, it may not be, Ukraine may not be able to impose a big enough cost. And so, you know, Ukraine may be unsuccessful, but I hope it's not unsuccessful, because if it is unsuccessful, then I think we will live in a world which will be harder for universities, harder for hospitals, harder for all manner of institutions, because the money that governments are spending on universities and hospitals, etc., will be going instead to defense ministries and to arms manufacturers. And because the world will go back to the way it was in the 19th century, where countries just took what they wanted. And I personally don't want to see that. If I, you know, for my children, and for, you know, for my, you know, for humanity, I don't want to see that. So.
Yes, indeed. In relation to that, also, Professor, we've seen that on the social media, there is a kind of racism on the refugees, like in terms of the reactions of the global discussion when the Russians started attacking the Ukraine, and the people started leaving their home countries, and the people, like the global, just reacted like we should help them. Meanwhile, we've seen that refugees from other states, for instance, let's say just like Mr. Riyad said, from Rohingya, they got a different reaction. What do you think about that, Professor?
I agree. I think that there is racism in all countries, and there are politicians in the West who have used that racism for political purposes. So the Brexit vote was tainted by attempts to make people in the United Kingdom fearful about Syrians and Afghan asylum seekers, etc. But I would also say it's not just racism. There is also quite a legitimate idea that it's best to resettle refugees close to where they're coming from, because resettlement back to their home country is easier. So it makes sense that Turkey would take a larger number of Syrians because Turkey is a neighboring state. It would make sense that, you know, Kenya would take a large number of Somali refugees because it's close. And it makes sense that Poland would take a large number of Ukrainians because they're close and they can go back easily. So I agree with you. There is definitely, I think, racism at play. And so for some politicians, you know, the ones who are fomenting these racial stereotypes, etc., they're using the different skin color, but there is also a dimension which is just the mechanics of resettling people. It is easier to resettle people close to where they are fleeing from. So.
Okay, thank you very much. I think last question from who is this? Habaib, Miss Habaib. Before we close. Yes, please.
Thank you for the opportunity. I would like to, since we've seen that all these legal proceedings have been instituted against the Russian Federation. I have actually two questions. First is how, in your opinion, how possible do you think all this legal proceeding can force Russia to go into the table and try to negotiate? What are the possible solutions? And the second is, if it might be possible for this legal proceeding or lawfare to be succeeded, what would be the long-term effect of this? Probably it can be a legal phenomenon for the future of the international law itself.
Sure. So they're good questions. So the first question, is it likely to force? I don't know. It really depends on whether or not the cost that Ukraine can impose on Russia is enough. And that cost is, you know, it's terrible, but it's measured in part by the deaths of Russian soldiers and the pressure that places on the Russian government. And it's measured on the economic costs that the Russian state has to address. But whether that cost is enough, I don't know. In terms of the broader implications of lawfare, I think the way that the globe, through globalization, is integrated, it's natural, you know, that as countries have closer economic relations, it's natural that when they try to pull apart in a conflict, it's messy. You know, there are lots of different actions, and it makes resorting to armed conflict more difficult because if your systems are really closely integrated, then fighting against each other is really, really messy and complicated. And so I'm a bit of an optimist. If Ukraine is successful, if Russia is forced to the negotiating table, and we can go back to a more integrated approach, then humanity has the potential to find ways other than warfare to resolve their disputes. And in a sense, Ukraine's litigation strategy is an illustration of something not involving weapons as a way of resolving a dispute. And so for me, the 19th century way of resolving disputes is what President Putin is adopting, and hopefully the Ukrainian position is the 21st century way that disputes would be resolved. And so I'm positive. I would see lawfare in a positive light in that sense, not as a form of harassment, but as a way of showing just how integrated we are, and a way that we do share understandings of certain facts. You know, we rely on the idea of a third party judge, resolving a dispute. And even in the United States, people contest facts. But I hope that we can rediscover the idea that we do trust other human beings to sit in judgment, and we don't think that they do that just based on what tribe they belong to, that whatever group they belong to, what race they belong to. They can do that in a way that is objective and not prejudiced against any particular group of people. So,
is that clear, Ms. Habaib?
Yes, I think it's clear, and it's very interesting to see that how lawfare can be the other alternatives rather than doing a physical war, especially in terms of in this 21st century. Thank you very much for the answer, Prof.
Thank you, Ms. Habaib. And so for your information, Professor Anthony, Ms. Riyad and Ms. Habaib are mothers. So they were so excited when I announced that you would be available for our Scientist Webinar Series.
Yeah.
So I'm so sorry, Mr. Riyad, that I think we have to finish the discussion because the time has come. And thank you very much again, Professor Anthony. I'm so happy to see you again. So it's reminiscing good times when I had to take their class. Yeah, very and I still have this. Look, I think that my my water bottle from the University of Queensland. And again, I think before we close this and handing this to our master ceremony, I think we have this photo session to all participants. Untuk semua peserta, mohon diaktifkan kameranya. Kita akan mengadakan foto bersama ya. Mohon maaf, admin bisa ini apa namanya? Why your kenapa muka baik yang muncul? How do I change it to? Okay, I think we have this a group photo together. Semuanya nyalakan kamera. Turn on your camera, please. Hitung 1, 2, 3. Next. 1, 2, 3. And next, I think how many? Oh my God, got 20. 1, 2, 3. 1, 2, 3. Yeah, this is the last page. 1, 2, 3. All right. Once again, thank you very much, Professor Anthony. More than 100 participants attending your webinar, Scientist, and thank you very much for your time. And then I will hand this to our master ceremony to close the webinar this morning.
Okay, thank you, Kak. Thank you for Kak Rafika Ramdi. Thank you again for Professor Anthony Kasimats for the enlightening and valuable knowledge about the Ukrainian and Russian war crisis in the perspective of international law. And before I close the webinar today, I would like to share the certificate for our beloved keynote speaker. Okay, thank you. This is certificate as a token of appreciation for Professor Anthony. Thank you very much. And yeah, finally, we have come to the end of our session today. On behalf of the committee, again, thank you for making your time in your busy and hectic schedule to join us here. And from the deepest of my heart, I do apologize if there's any mistake conducted by the committee, or especially from me. And wish you all the best in the future. And yeah, let's see. See you next time. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much. Thank you, Prof. Anthony. Thank you, Prof. Hamza.
Thank you, Prof.
Thank you, Prof. Anthony.
That was amazing.
Thank you, everyone.
Professor.
Thank you. Thank you very much for the invitation.
Thank you.